Thanks for joining us for another fall edition of our Elville webinar series. It's Wednesday, November 12th, and our topic is Learn what elder law attorneys are advising clients in 2025 and into 2026. And there's no one better to take us through this discussion than our President, CEO, and Managing Principal, Stephen Elville. How are you doing today, Steve?
Oh, good morning, Jeff. I sure wish you would turn the heat up, but besides that, I'm doing really well. And happy Thanksgiving to you and everyone else.
Yes, for sure. It's wonderful to be in this start of this holiday season. And a few housekeeping items as we get started with our presentation today. We always encourage your general questions, so please note them in the questions panel, and we'll pause periodically to address them. And yesterday by email, you received the presentation slides Steve will be referencing, and they're also available in the section marked handouts on your screen to download at this time. And everyone will also receive a post-webinar feedback email right after the presentation. Please take just a couple minutes to share your thoughts and offer us some feedback about today's presentation. And welcome to our advisor community as well. 1.5 continuing education hours are available for most everyone in attendance today. Please send me your accreditation and or an ID number so I can submit your hours for approval and send certificates out to CPAs. And a question for you, have you achieved your planning goals? Or have those goals shifted since you last looked at your planning, which may have been a year from now or maybe 20 years ago? Here at Elville Associates, we're always a leading resource for your family's planning needs. And whatever it may be, if you're starting from scratch, if you have older documents need to be reviewed, an administration matter, special needs planning, Steve and his team are really here to help you and guide you through the entire process, understand your individual situation, and create some solutions and a path forward for you. So I'd like to talk just a bit about Steve and the firm. We'll jump right in. So we start on time and end on time, as we like to say. So we are Elville Associates, founded in 2010 in Columbia by Stephen Elville. We have many different practice areas that our attorneys focus on here on a daily basis. They include estate and special needs planning, elder law and elder care planning, estate and trust administration, business law and succession planning, guardianship and litigation, along with tax planning and asset protection techniques. We have 14 attorneys now. We are growing here at Elville Associates. I'm very proud of that. 13 staff members in 3 locations. Our mission, it's always been the same since Steve started this firm in 2010, and that is to provide practical solutions to our clients' needs through counseling, education, and superior legal technical knowledge. And we focus on education a lot here at the firm, as you'll see today. We do it in several different ways. Just a few of those include through our planning processes with our clients, and we have different programs to suit all individuals and families here at Elville Associates. We offer educational webinars and workshops in the communities that we serve each year, and also by way of our accredited client care program. We're one of only 2 firms in Maryland to have a client care program accredited by the Client Care Academy in Boston. We also work with the ideals of client education, collaboration, and compassion in mind with every client every day here at Elville Associates. And just a bit about Steve. We could talk all day about Steve, or I could, but I'll keep it to about 30 seconds. His work as an attorney for the past 25 years has been centered in elder law, special needs planning, and estate planning. He's a member of many different national membership and professional organizations, including the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, Wealth Council, nationally recognized peer groups, and many others. Steve works to offer peace of mind to clients by creating solutions to their needs through counseling, client education, and the use of leading-edge legal technical knowledge. Steve is a very seasoned speaker, as you'll hear today if this is your first time joining us, presenting at many webinars, conferences, continuing education events, and more each year. And Steve was named to the Maryland Super Lawyers list for a 10th time and 9th consecutive year in 2025. We'll see in about a month what 2026 brings for Steve. He also had a feature story written about him in the National Super Lawyers magazine about the Elville Center for the Creative Arts, which is our firm's charity that Steve founded in 2014. I'm very privileged to be the director of. If I were to turn my camera around right now, you would see, I would say, maybe about 30 instruments, a drum set, about a dozen guitars, lots of equipment, which is one reason I have a big office. That's the only reason I have a big office. So if you want to learn how we work to make a musical difference in the lives of children each day, I would love to share our story with you. Please reach out to me directly. Steve, let's have a good presentation. I'm going to make the presenter change in 1 second here.
Thank you very much, Jeff, for that nice introduction and for all that you do for me and for Elville Associates and all you do for our firm's charity, the Elville Center, as the executive director of that charity. And I am trying to get to the presentation, which I'm going to get on to the slideshow. And there we go. Thank you so much, Jeff. I hope you can see that.
I can.
And I just want to thank everybody for taking your valuable time on a Wednesday morning, and to invite you to just relax and take in the information that we're going to be talking about over the next 50 minutes or so. And I welcome our past clients and current clients, prospective clients, our collaborative referral relationships, such as our financial advisor friends and CPAs, life insurance specialists, life care managers, and on and on. I can't express my gratitude enough for your support of our webinar series, and I wish everyone a happy Thanksgiving in advance, wherever you are. And I don't know what the status of the government shutdown is this morning, but I know many of you have been affected and continue to be affected. I just had a lunch cancellation because the person I'm supposed to meet with cannot get to the DC area from Arizona. So we know many of you are being affected, and hopefully this is going to end soon, and all the inconveniences and the travel problems will be resolved prior to the Thanksgiving holiday, and hopefully well before that. So thank you again for coming, and I want you to get out a tablet, an old-fashioned piece of paper, a phone, whatever it is that you can make some notes on, whatever it is that you can do to memorialize certain things that you may find interesting today or important. And our whole goal here is to impart education and to let you know where resources are. That's our function in 2025, is to be counselors at law and providers of resources and information. We also want to solve legal technical problems, but we want to do that in partnership with our clients and address needs. So if you are not a client, we just invite you to learn, and then we can always enter into a attorney-client relationship. But obviously, this particular presentation is a high-level series of educational presentations in the form of these PDFs we're going to share. It is not meant to be legal advice, but we can enter into an attorney-client relationship if you need advice. And with that in mind, we're going to get started. And I'm just going to say that everything has its premise, whether it's a novel or whether it's what we're going to do today, whether it's a screenplay, whatever it is that could be something that we could say, hey, this is an activity that has a premise, it has a starting point, it has a foundation. So what would I say the premise of this particular presentation might be? Well, in my opinion, just sitting from where I sit, the most important thing to take away, even though you may take away many things today, the most important thing to take away, in my opinion, from this presentation is the idea of getting clear of a lot of myths that surround elder law. The world of elder law is a sea of ambiguity since the time of its recognition in the early 1990s. So a lot of people ask, what is elder law? I would say it is the intersection of where estate planning and disability planning, or long-term care planning, or asset protection planning for long-term care, and special needs planning for spouses and others. This is where the intersection of elder law and estate planning meet, or where the disability section meets. So this is a juxtaposition of two somewhat related, but sometimes opposing trains of thought. Not to mention veterans benefits and other things like that that can be similar but different. And how do we deal with costs of care and all of these kinds of things? So understanding that there's a lot of myths, and also understanding the power of the elder law consultation. In other words, one of the things to take away from today is that there are answers. There aren't as many answers sometimes as we would like. For example, under OBA, the One Big Beautiful Bill Act, where there are winners and losers. Clearly, people of wealth, people who are growing their assets, people who are doing estate planning, clearly these are the people who are the winners under that bill. And if you have more questions about that, we can provide information. We have a client care program where we're going to be talking more about OBA in December. And then on the other hand, there are people who we might call the losers or potential losers under this bill, those who rely on Medicaid benefits, as many of you have been reading so much about in the news. We honestly don't know what's going to happen in 2026. Nobody really knows how that trickle-down effect is going to affect us. We just know that there's a big epic situation on Capitol Hill, and these are existential problems, right, or issues that are being addressed. The one thing we can take away is that through education, we will be better prepared, and through flexibility in planning, we will be better prepared. So that is the major thing that I would ask you to think about taking away today, is many questions, whether they are housing related, Medicaid related, special needs planning related, disability planning related. Many of these things are going to have lots of ambiguities. We can clear up many of those in an elder law type consultation, and I would recommend that for you and your family, or someone you know who is really burdened by all of the confusion surrounding all the scope of these issues. Okay, with that said, we're going to do what Jeff said. We're going to get started, and we're going to end on time. So why are clients coming to see elder law attorneys in 2025? Well, there are the same old problems, age-related problems, obviously. We are all getting older. Statistically, we are living longer. Many of us are not healthy if we live too long and we haven't taken care of our health, or there are genetic related issues and family history issues. But all this comprises a situation where there is a sea of people who are getting older, and we have these age-related issues. Some people come to see an elder law attorney for pre-crisis planning. There hasn't been a health crisis or a long-term care planning or cost-related crisis, and so we want to get ahead of that. And that is a big thing. If you can put a star right beside that, pre-crisis planning is where we want to be. We don't want to be in the crisis mode without any pre-crisis planning, and we don't want to be in the post-crisis mode where we were caught unprepared. Change of circumstances, obviously, someone can be healthy and well today and not healthy and well tomorrow, God forbid. So change of circumstance drives this. Crisis drives this. We just talked about that. Maybe it's not you that are getting educated for your own self, but for your parents or other relatives that are aging. Many of us are caregivers. Many of us are living with relatives and they're living with us, I should say, and we are taking care of those relatives and wearing three hats. Grandparent issues, same issue. Disabled children or other loved ones with elder care related issues. So nothing much has changed in this regard. We're always counseling people about healthcare decision-making. Healthcare decision-making in Maryland has not changed too much, but you need to educate yourself about that. We're going to talk more about that. Financial decision-making. To me, the most important of all these things. Now, these bullet points are all important. They're all important. But the financial decision-making piece is where we have the least flexibility, and we need to understand that getting ahead of that is where we want to be. In-home care and in-home care management, right? The most expensive of all options for long-term care. Nursing home and assisted living placement, making sure we've read those contracts, making sure that we have the proper care. We have certain clients right now that are paying a lot of money for assisted living. Some of them are happy, some of them are not happy, and saying, hey, for what I'm paying, I should be receiving a higher level of service, okay? We know these are difficult issues. Estate planning, again, planning for death, but also planning for flexibility during life. Asset protection. Asset protection comes in different varieties. What kind of asset protection are we talking about? Well, in this webinar, we're talking about asset protection in the long-term care context. How can I preserve assets for my loved ones' supplemental needs while still taking advantage of what is offered for certain government benefits? Or how do I use our financial assets to provide for our loved one in the best way possible, using a planning team and proper investments and long-term care insurance or long-term care hybrid products. All of these things are about asset protection. Understanding and limiting liability if you are hiring private caregivers. This is always a big issue. Again, assisted living, nursing home contracts, CCRCs, continuing care retirement community. Many of you have loved ones or even yourself live in these communities. Medical assistance, Medicaid in Maryland, understanding the different types of Medicaid and navigating the real, sea of ambiguity that we're dealing with. Medicare issues. Why do most elder law attorneys not deal much with Medicare? And that is a mystery to some people. And Jeff, I'm having trouble getting to my bottom bullet point here, which I can't really see, so I'm just going to go to the next one. And I'm just going to make sure. I apologize. I just can't read the last bullet point, so we're going to skip to the next slide. So why do I make such a big deal of this elder law consultation, and why is it a basis for change? Well, the main thing is it clears up ambiguity, so we're going to go through this list. But when I first became a lawyer, when I was a young lawyer, and I had the opportunity to learn the field of estate planning, the field of elder law, the field of special needs planning, and a little bit of business law, and a lot of tax planning, on the elder law side, I found that there's not only a lot of confusion, but there's a lot of pain. Let's be honest. There's a crisis or a pre-crisis going on. There's aging going on, which is, we're not excited, all of us, about getting older necessarily, and all of the related problems. So I found that through the elder law consultation, this is where myself and others could make a big difference in the lives of people who are suffering. Not only the person who has the disability or illness or progressive illness, but the family members who are looking for answers. So this is why I am emphasizing this to you today, for you taking the time to sit through this material. What is an elder law consultation? It's a fact-finding session. It's a lot of listening. It's a lot of listening on our part. Identifying problems, figuring out what the goals are, giving a family an overview of incapacity-related issues, and an overview of the long-term care world, the world of Medicaid, the world of medical assistance, the world of waiver programs, and that is a foreign word for some of you. The world of multi-jurisdictional issues. What is happening in other states versus Maryland, and what are the options? Okay, discussion of professionals who should be involved. Aging life care managers, insurance specialists, working with your financial advisors if you have one, and helping you to have a financial advisor if you need one. But really looking at the costs of care, or the potential costs of care, and long-term care financing techniques, along with asset protection. So this is a big ask, right? This is a big thing to ask someone to come in. And after attorneys like myself have been studying this for years and listening to workshops and seminars for years, this is a lot to ask somebody to come in, make notes about, and make sense of in a couple of hours. So we have to be kind to ourselves, and we have to realize that these are not only counterintuitive issues, but these are foreign issues. These are things that you would not be dealing with in your day-to-day life. But we need to give ourselves permission, especially if we're doing crisis planning, but hopefully pre-crisis planning, to start to breathe deep and just understand the landscape of these issues, because they are so ambiguous. The elder law consultation is basically a planning shift. It allows us to understand and make adjustments if needed. It resolves ambiguities, as I mentioned. It relieves anxiety and hopelessness among a lot of people. That is a very big thing. It provides a sense of direction and empowerment. It can create family unity towards a common goal, and it can address weaknesses in family structure where certain people do not get along, God forbid, and how do we deal with that? Let's talk about the three types of asset protection, because a lot of people talk about protection from creditors, talk about providing asset protection at death, but what we're really mainly talking about here today is the one in the middle, long-term care type asset protection. Asset protection in the long-term care context. But first, in my opinion, to understand that, we have to look at the different types of asset protection. Let's just take, 1 minute on this particular topic here. Lifetime asset protection. This is really a difficult thing to achieve. However, some things are asset protected, meaning protected from the claims of general creditors, not anything to do with long-term care. But look at IRAs. IRAs and qualified plans are protected from creditors. Annuities and life insurance are protected from creditors, so long as your spouse or child is the beneficiary. So many of you did not know that. Tenants by the entireties. If you're married and you have a marital form of ownership of a piece of real estate, your residence, or a brokerage account, that is going to have a basic level of asset protection. It's not 100% bulletproof, but it is a basic level of asset protection. This is the idea of how can I protect assets during my life, which is the more difficult thing to do, especially when we look at the bottom bullet point where it says domestic asset protection trusts. Well, the best way to describe that is our friends in Delaware. That is a asset protection state. We can achieve greater asset protection, arguably, in Delaware due to Delaware law, and that Delaware is one of the 16 to 18 asset protection states. So this slide doesn't necessarily have anything to do with Medicaid or long-term care, but it is a good groundwork to know before we move into the long-term care idea. I'm going to skip to the next slide and then come back to the long-term care slide. Then kind of at the opposite end, we have asset protection for loved ones at death. So this is another subject for another day, but just know that good planning can encompass providing for trusts for others at our death. So if we die, God forbid, we leave a trust for someone else, a third party, a spouse, a child, grandchild, niece or nephew, or friend. We can structure that trust in such a way that there is asset protection from general creditors. And of course, special needs planning falls into this category. Not that special needs beneficiaries have creditors many times per se, but this is a third-party trust concept that we can leave assets in a third-party trust to protect others, whether they are healthy and well or whether they have disabilities. Let's go back now to this middle category, which is what we're really talking about today, asset preservation in the long-term care context. This is the heart of elder law, and it involves these things, even though we don't have time to talk all about it, all encompassing. Medicaid trusts. The Medicaid Asset Protection Trust is arguably the most powerful tool in all of estate planning, not just in elder law, but it's a powerful tool. It combines several different things into one powerful package. We did not create it here at Elville and Associates. This kind of trust has been around in the elder law community for at least 20 years, but we are more well known in Maryland as I would say proponents and users using the utility of these kinds of trusts for the benefit of our clients. Similar type of trust is the Veterans Asset Protection Trust. This can be a powerful tool for those who want to do asset protection planning for long-term care, but also take advantage of tax-free VA, Veterans Administration pensions. The use of trusts under wills. This is a strategy for married couples where one of the spouses, unfortunately, is suffering from a progressive illness. So this is something that you need to know more about. We do a lot of this kind of planning. And in recent years, Maryland has sanctioned, I guess is the best word to describe it, has sanctioned this kind of planning in a greater way. So we have this powerful tool. Crisis planning is the 5-year look period, the look forward period, not the look backwards period, even though it's called a look back period. Since 2005, During the George W. Bush administration, this was changed from a 3-year look period to a 5-year look period. So this is where the use of asset protection trusts come in. This is where, whether you have long-term care insurance or not, it could be a tool to use in conjunction with such 5-year planning. But if we do no planning at all, except we have the foundational documents. What do I mean by foundational documents? A will, financial powers of attorney that are very robust, and advanced medical directive. If we have that financial power of attorney and it is robust because your particular situation allowed you to create a robust document and you trust your agents literally and you have faith in their fiduciary duty, you can create a situation where even if you did no crisis or pre-crisis planning, you could, under a crisis type event, you could preserve at least 50% or roughly 50% of your assets. This is called the rule of halves. The life estate deed is a way of avoiding probate, and in the elder law context, it is a way to start the 5-year period without using a Medicaid trust. There are pros and cons of this. It is a simple approach, not necessarily the best approach, but we can preserve a house or piece of property if we can get beyond the 5-year period for Medicaid, so long as we have given up the power of sale. That is a big deal, to give up that power of sale. So we don't necessarily want to give that up lightly because that decision is irrevocable. So these are some of the strategies and ideas that are discussed, or the tools that we have available to us, among other things, if we are engaging in elder care type planning. Now, when clients are counseled, they want to know the following things. And when you are sitting where you are right now, in your particular situation with your particular loved ones, or long-term care situation, if you have aging parents, how can I pay for the cost of assisted living? Now, why is this such a big deal in Maryland? Okay, well, take this for whatever it may be worth. It is just an opinion. Maryland is one of the lesser, if not one of the worst places to live if we are aging in place. Now, that's not going to be a surprise to some of you, but it's also not going to be a very good piece of news for some of you. Why is that? Because Maryland, generally speaking, does not have its waiver programs, and that's something we can discuss more in person. It does not have waiver programs that allow people to stay at home or live in assisted living without having to go to a nursing home. It does not have a robust waiver program like Delaware or New York and some other states. So we have to accept, unfortunately, that it is generally, not always, but generally private pay if we are at home, being cared for at home, or going to assisted living. It is only, generally speaking, not always, generally speaking, only the state or federal government will pay for long-term care if we are in a skilled nursing home. And of course, we don't want to be in a skilled nursing home if we can at all avoid it. We don't want our family members to be in skilled nursing homes. These are the topics of hot discussion. Will I lose my home? The answer is no, so long as we've done proper planning. Maryland does lien properties. We have to be aware of this. We have to plan for it. How will I survive in the community? Well, if you're a surviving spouse, the government has provided a way. It is not a pretty way, a pretty thing, but the government has provided a bare minimum way that a surviving spouse can preside in the community, survive in the community. We would discuss that inside of an elder law consultation. How do we preserve our assets if that was a goal? Because remember, all planning is goal driven. How do I deal with the placement of my loved one? Sometimes this involves attorney help or paralegal help. Sometimes it involves aging life care manager help, the professionals that are out there. Healthcare decision-making for my loved one, and will I need guardianship? Well, we hope guardianship would not be needed. Guardianship is there for a reason. It's a last resort. It's the highest form of intervention. However, we're hoping we don't need guardianship because guardianship means, in my opinion, the loss of flexibility. The flexibility we could have otherwise had the person at issue, the sick person, the ill person, had they had basic, fundamental, foundational documents in place. Can I get veterans benefits? Well, there are new rules since 2018. Some of those rules are more restrictive, but in many ways, this is much more freeing. And those people who have served, those veterans who have served in a period of war, and they meet certain criteria, we can now plan for those people to receive tax-free benefits. And the VA has many pensions, there's much to go into, but that is a big deal for some people, and we want to be cognizant of it. How to title assets after we've done an elder care plan. How do I care for my impaired loved one at home? All these types of issues, we want to be facilitators of not only information and planning and legal technical solutions, but also of resources like life care managers. And if we are in a CCRC, continuing care community, are those assets preserved? Can we get VA benefits, and can we still preserve assets under the Medicaid laws? These are sometimes good news, sometimes bad news when we get answers to these kinds of questions. Now, when we confront these issues, there are some action items that usually have to happen. Hard decisions about placement or healthcare decision-making, hard decisions about whether to transfer assets, hard decisions about changes to the estate plan, okay? But look at this bottom bullet point. I've mentioned this several times, and I cannot emphasize more strongly. The use of aging life care managers, such as Jill Rossner, Marcy Koenig, and Allison Stanton, and many others. These are the professionals that are out in the community dealing with aging and staying at home and / assisted living and other nursing home placements. These are the people who could be tools to you. And I cannot strongly recommend that you take advantage of these top professionals and how they can advise you and be of help to you. Now, in the elder law context, there are certain recommendations. Let me speak about this type of next steps and recommendations concept. When I was a young elder law attorney, it seemed to me that there were certain people who were, let's say, the senior elder law attorneys in the practice of law in Maryland that were basically able to give people a lot of information, but for some reason were reluctant to give people really solid next steps. This was just my perception. Maybe it wasn't true, but I did sit in many types of situations where I saw attorneys taking this approach. What I have learned over the years, and I'm very proud to say that Elville Associates and other elder law attorneys that I know in the state of Maryland take a more proactive approach to really help people try to find solutions, not just to become educated, but to have very solid next steps to be proactive and to advocate for that proactivity. So this is one of the major changes. And I will also say that there's been a lot of changes in the law that make this kind of proactivity a very rewarding thing, because we have a lot of flexibility in the law itself as compared to 20 years ago. So not only do we need flexibility in the planning documents, and we need to get ahead of a crisis before it happens so that we don't lose that flexibility, but you can rest assured that there is flexibility in the law itself, much more so than it was in the past. But when someone, let's say a married couple, leaves an elder law consultation, there's going to be a certain set of, how should I say, tiers of recommendations. And the way that I approach this, because the information is overwhelming, the scope of information is overwhelming, the information, as I mentioned earlier, is counterintuitive. So for many people, it's just too overwhelming to be able to comprehend, although most people do a very good job of absorbing the information. So I believe if you look at elder law and you look at the potential possibilities of what to do next, depending on the circumstances, depending on the level of care, Level of care is huge. Level of care determines everything as you go forward in an elder law type situation. That is why the aging life care managers or others who can assess the level of care, and speaking about multi-jurisdictional issues, as crazy as it may sound to some of you, should I utilize Delaware law and Delaware long-term care planning versus Maryland, okay? And of course, we could have relatives in other states, and we need to bring in professionals from those other states, such as certified elder law attorneys in places like New Jersey, New York, other places that loved ones, Florida, South Carolina, wherever our loved one may be. So just as a very general thing, some people are going to take a wait and see approach. The crisis, heaven forbid, has not developed yet. It hasn't fully developed, and hopefully it never will. So this person, this couple is going to provide a lot of flexibility, and they're going to wait and see. Then as time goes by, that couple might transfer assets between themselves. Whoever the ill spouse is, there might be a reason to transfer non-retirement assets out of the name of that spouse, not IRAs generally, because that would trigger tax. And then, of course, a lot of people are interested in a general pre-crisis consultation. How can I preserve assets for my children, grandchildren? I want to divest assets in advance of a crisis. So that's a counseling session in and of itself. And of course, many people, unfortunately, are dealing with a crisis. And the first thing that we're going to ask ourselves at a time of crisis for a married couple, and this is a very unpleasant situation where someone has had a crisis, obviously. A stroke could be the type of situation we're dealing with, and that loved one who was healthy yesterday is now in a nursing home. The loved one who was healthy yesterday now has a brain injury, a traumatic brain injury. Now, what we're going to first look at is what documents do we have in place? Do we have flexibility? And can we preserve assets for the well spouse in a married couple situation? The answer is generally yes. But the question is, do we have to have court intervention, or can't we just do this privately because the couple has done good planning? For the unmarried person, there could be similar options, but not as many for the preservation of assets, because the Medicaid laws are not very favorable for single people. I don't know why, but in the world of elder law, the Medicaid laws are favorable in the sense that they allow a well spouse who is going to continue to live in the community to have a certain amount of protection. Now, remember, mind you, that all of this discussion has nothing to do with your private financial affairs, your financial advisor, and how you may have invested and saved money over the years, whether you have long-term care insurance, whether you don't have long-term care insurance. These are the legal type options, not necessarily the financial driven options. The beautiful thing about having the financial and long-term care planning options marry into the legal technical is that this is where we can meet the world of elder law head on and have good results, because we've not only planned in advance financially, but we've planned in advance fundamentally with the legal technical documents. So if that makes any sense to you, we have a basic set of tiered recommendations, generally speaking, not always, for single people versus married people, and various options that are available for single people and married people. Understanding this flexibility is everything, and that takes us to a very brief discussion of incapacity planning. If you've never heard Elville and Associates present before, you may not have heard that the most powerful of all documents is the financial power of attorney, whether it is in the elder law context, or whether it is in a super wealth transfer type context, or whether it is in a foundational estate plan or a very advanced estate plan. The financial powers of attorney are the most important documents of all documents in estate planning, especially in elder law. Does that mean the advanced medical directive is not important? Not at all. But from an attorney's point of view, the financial power of attorney is where the rubber meets the road, so to speak, for flexibility. The advanced medical directive, of course, is very important. And a properly structured set of these documents with the correct agents who are going to get along and exercise their fiduciary duty and responsibility for your benefit, you will never need a guardianship. And hopefully there's a 95% chance guardianship of your person and property would be avoided. Now, Maryland has a statutory power of attorney. I'm not going to go through every one of these slides, but many of you have seen a Maryland statutory power of attorney. There are two types. One is a longer form and one is a shorter form. And these forms came out in 2010 when the Maryland Power of Attorney Act came out. I'm emphasizing this because the Maryland statutory power of attorney continues to be updated over the years by the legislature, and there are more and more long-term care planning and elder care powers being included in these powers of attorney. But we recommend that even though this power of attorney is enforceable by law, it is a very good thing for the general public, and it's a very important tool for you. We recommend that you look beyond this statutory form, which is very important. You look beyond this to your general power of attorney to provide the kind of flexibility, the kind of gifting power, the kind of compensation power, the kind of trust creation power that you might provide to save assets, to provide flexibility, to accomplish your goal, whatever that may be with regard to elder care planning. I'm just going to pass through these slides in the interest of time. As I mentioned, the advanced medical directive is very important. We highly recommend that you customize it and that you customize it along the lines that it is understandable and yet still legal, and it conforms to the law. But we want you to also know that this document is very flexible and it has to just make sense, but there's no limit on how you can customize this within reason. So just remember, your loved ones or your agent will not know what you wanted unless you make it clear. But when we make it clear in customizing this document, we have to do it in such a way that it is sensible, clear, and legally effective. So those are the only limitations. All right, let's go to the next slide now. Many of you are familiar with the medical order for life-sustaining treatment, which basically became fully effective in Maryland in 2014. Many of you have not heard about this. I want you to educate yourself. This is not an advanced directive. This is, however, where the do not resuscitate order lives, and that's a very serious thing. You do not need, generally, a MOLST form, a medical order for life-sustaining treatment, unless you are in a facility or you have a chronic or terminal illness. But with that said, it is required by law in Maryland, and you need to learn about it. And one of the ways of learning about it is to go to the Attorney General's website, which is not very exciting, but here you will see video and other things talking about Maryland healthcare law. You also should talk to your doctor about whether you should have a MOLST form, but generally speaking, it is not required unless you reside in a facility. Now, Jeff, we've left plenty of time for questions. I want to just say to our great audience here this morning on a Wednesday morning, thank you for hanging in there with me through some dense discussion of the foundational information about elder law. You may have some questions this morning, so I'm going to be here till 11 o'clock to answer those questions. Once a financial advisor friend of mine said, Steve, I want to congratulate you on educating people and, you know, let's say, hopefully being very effective at that. So I thanked him very much. But then he said in the next breath, he said, Steve, we have to give people a clear path forward, and we have to give people a way to organize their planning. So I always remembered that, and I thought it was a very good suggestion. And for many of the financial advisors and other professionals on this Zoom call this morning, I know you do that, and you're always working on that for your clients. For people on this call this morning, attendees that are not part of our financial advisor or CPA or life care manager or insurance professional community, we encourage you to please understand that if you come in and get a consultation about these issues, that there is an attorney-client relationship. Even if you do not become a client, so to speak, when you come in to discuss issues, we do have an attorney-client relationship. For elder care type consultations, we do charge hourly, but for general estate planning consultations, we do not charge hourly, and we set flat fees many times for those types of consultations. But my point of that is that there's nothing to fear, and the attorney-client relationship attaches, and the confidentiality attaches to that meeting. So there's really nothing to fear, and we would love to look at your current documents. We would like to help you form an advisory team if you don't already have one. Answer questions. We love your questions. We love seeing lists of your questions, or just come in and say, Steve, I want to set some goals, or one of the other attorneys here at our firm, different locations. I have some goals and I want to explore ways to accomplish those goals. More importantly, and maybe the most important, we want to give you time to think in 2025. At the beginning of the pandemic a few years ago, Jeff and I concluded that maybe the number one thing that we could do for people, clients, and the community at large, was to give people the time and space to think. So that's why we have some very large conference rooms equipped with all the latest electronics, tools, all the things we need to counsel. And if you don't know what your goals are, well, you're not alone, because a lot of people don't know what their goals are. Some people really do know what their goals are. Regardless, we are helping. We're here to help you go from where we are now to where you want to be, or to assess where you are now, assess your documents, and really be in a partnership with you. At the same time, provide the highest form of legal technical advice that we can give you, and at the same time, just helping you have a path forward. So Jeff, we're well within our time this morning. I don't think we had any questions, but I want to thank everybody. And hopefully what I've done this morning, Jeff, is emphasize 2 or 3 or maybe 4 key points, among other things, that our attendees may walk away from, and to let them know that there is a path forward to provide or to obtain information in a partnership type relationship with them or with the financial advisors that help them and others. Jeff, I'm going to turn it back to you.
Okay, Steve, thank you very much for that comprehensive overview of elder law. We do have a question that just came through. And that question is, if I give someone power of attorney, can I decide to withdraw that power? If so, how do I do that?
That is a wonderful question. Thank you very much. So the law, almost in all states, says that when you empower your agent and you are the principal, you're empowering that person, you now have to give them notice in writing that their power is no longer effective. So when you say, I do not want you to be my agent, you have to give that person notice in writing. And that is a very important thing, because that is what terminates their authority as your agent. Great question.
So Steve said now is a great time to get those final questions in, if you have any. I always send out a pretty comprehensive email afterwards with the video, slides from today's presentation, and some other substantive information that Steve talked about during the presentation. I'll do that by about noon today. As far as our webinar series, it continues forward as we look into the new year, 2026 already. It's hard to believe. On Thursday, the 20th of November, we'll have Dr. Michelle Fritsch back with our wellness series, a holiday edition. And on Tuesday, the 2nd of December, I'll be putting on my presenter's cap and talking about the client care program. It's always a good time to join our client care program. Lots of great things going on, lots of benefits, but there's no better time than the end of the year, so you can take full advantage of all the events coming up throughout 2026. So I'll be talking about that on the 2nd, and on Friday the 5th, Steve will be back to talk about the essentials of estate planning and special needs planning, which is a presentation that we offered at the Howard County Library Central Branch about 2 weeks ago. It was a really well-received presentation. Look forward to offering that through our webinar series. So I think those are all of our questions, Steve. Steve, thanks for being here today, and to you, our attendees, for being here as well. We'll see you again soon on the Elville webinar series. Have a great day.
Happy Thanksgiving, everyone. Thank you.